Welcome to Mike's Minutes. My name is Mike Dunn, Wealth Advisor with IPC Securities. Today's video is actually not going to be about investing. We're going to talk about a very important topic, which is in wealth planning, which is estate planning. Today I have a special guest, Raluca Soica, who is a wills and estates lawyer here in the GTA. Raluca, I want to thank you for joining us today.
Thank you for having me, Mike.
No problem. It's always great to have other professionals on here. And as always, the purpose of these videos is to provide as much education as I can. And I want to be very clear that I'm not recommending anything. These aren't recommendations. Everybody's situation is different. It is just some education. And we always recommend that you seek advice from professionals on these important topics in your life. If you would like further information on the topics we discussed, please reach out to me at mike.dunn@ipcsecurities.com, and I'd be more than happy to have a further conversation or answer any questions you might have. So let's get right into it. Estate planning is a very complex topic, but today Raluca will answer some common questions that generally come up when it comes to wills and ownership of assets. So Raluca, the first question that comes up quite a bit is, why is it important for somebody to have a will?
Well, thank you for the question, Mike. Let's review what a will is and what it does. So a will is a formal estate planning document. It's a legal document through which you dispose of your property and you appoint guardians for your children. If you don't have a will, you give up a host of things, and I'll go through a few of them that you give up. So the first is you don't choose who receives your money. That's right. You will be considered intestate, and as a result, your estate will flow through intestate law, and the government decides how your money will be distributed. So if you don't like that, then consider having.
I don't know many who will.
The second, that's a pretty big point of contention for many of my clients. You don't choose what percentage of your assets go to your favorite charity. You don't appoint a guardian, a temporary guardian for your minor children. You don't plan for decreasing estate administration taxes or any other types of taxes on your passing. And you don't choose who will administer your estate. This last point is important because there's the family dynamics. It matters a lot in estate planning, and choosing somebody who is well liked and respected by everybody else in the family and who handles finances properly is important. So it's a lot to give up just by choosing not to have a will.
Yeah, very good points for sure. The second question that often comes up is, I don't own many assets and I feel like I don't really need a will. Is that kind of a wise mind frame for somebody to have?
Yeah, that question does come up a lot. And sometimes I do recommend to clients that there really is no need for a will, because I look at their situation, I ask certain questions, and I draw that conclusion. But of course, like with anything in law, some complications can arise, and that people generally don't consider, and they don't look at it as part of an estate plan. The first and the most popular one is for families with young children, minors under 18. They don't really get to appoint a guardian in the will, and usually a temporary guardian is appointed, and that this person helps take care of the children in the immediate vicinity of the time when the parent passed away. Also, with respect to insurance designations, a lot of people don't look at this as an asset because they don't own it, they can't use it while they're alive. But in insurance designations and leaving money to minors, the insurance company, on their form, they will ask you to designate a trustee, and you will do that. And then you will think this topic is completely taken care of and covered. But what people don't know is that this document does not create a trust. So it doesn't create terms for how this money should be administered. And for life insurances, you think, large sum of money, 500,000, $1 million, that's a large sum of money to not have directions left somewhere for how it will be administered. And what ends up happening often is that the Office of the Children's Lawyer gets involved. They take control of the money, and they end up administering the money on behalf of the children until the child reaches 18, even though a trustee was appointed in this insurance document. So a will definitely help take care of that.
Okay.
Yeah, and there's, of course, many other things that can come up on an depending on an individual's personal situation.
Yeah, again, that's why it's important when no different than a client working with me or a lawyer, an accountant, where it's the more we know about somebody's situation, the more that we can use our expertise and develop a plan that is catered to them. And, in today's world, with a lot of people having significant amount of debt, a lot of younger people, they have kids. That's actually really good points because, knock on wood, anything can happen. And if you have a large sum of insurance, no will, you have kids, a lot of complications, for sure.
Sometimes that's the largest asset for younger families.
Yeah, oh, for sure. For sure. So the third question that I have here, so I have a will, but it was drafted many years ago. Should I update it, or really how often should I update a will?
Well, if you've just had a will done, I would say maybe there's no need unless there was a major life change in your life. Generally, major life changes mean divorce, a remarriage or a marriage, kids growing up and leaving the house, death in the family. So to give you an example, I've dealt with a situation, an estate plan, with a person who had a will done, and subsequent to having the will done, one of his children went to the States and lives there and is a resident of the States, and the other child became disabled and is on ODSP and a dependent. So in this situation, two different types of trust needed to be created to address the needs of both of the children. And that could have not been addressed by the previous will that just left money outright to each of these children, and it would have a significant tax impact on their situation.
Yeah.
So I would say the rule of thumb is to look at your situation every 5 years.
Okay.
And if there's any major changes, then consider talking to a professional about this.
Yeah. Yeah, even especially the younger generations too, there's a lot, like within 10 years of their life, there's a lot of things that happen, buying a house, having kids, maybe relocating, whatever it is. So for those younger clients watching this, seek a lawyer and discuss a will. It's definitely very important. Okay, that's great. So the last question, it deals with ownership. So, many people believe that having joint ownership with somebody on as many assets as possible is kind of like the trick in estate planning. What are your thoughts on that?
This is the question I probably get the most often, and I've written articles on this topic as well. Sometimes it is the appropriate avenue, and I usually make that recommendation after I've reviewed the person's estate plan, after I reviewed their assets. I ask them a lot of questions about family dynamics, etc., etc. But sometimes it's not the right avenue, and a lot of shall we say, unknowns can crop up that people are just not aware of. And it's one of my favorite topics to educate people on. So So for example, one of the complications that can arise in real estate or otherwise is the identity of the co-owner. If the co-owner is a spouse and the property is owned in joint tenancy with that spouse, then it's very, yes, absolutely. Then that doesn't need to be included in the estate plan, and the property will flow outside the will. There will be no estate administration tax payable, and a host of other taxes are exempt because there's something called a spousal rollover provision in the Income Tax Act. However, if the identity of the co-owner is a child, an adult child, well, a minor child, that's just downright not a good idea. But an adult child, a lot of parents put in assets in joint ownership with their adult child, and things that come up that they don't think of could be creditor claims. So you expose that asset to the child's creditor claims, if that is a possibility in with the child. Marital claims: is the child married? Is the child divorced? If the child is married, how is the marriage? Is it good? That's something that you might consider protecting your asset against. And of course, the topic that everybody likes to run away from or reduce is taxes. So if the child doesn't live in the property, that's not a primary residence for the child, and there will be capital gains tax payable on the death of the parent. And these come from the estate of the parent, and there will be less money left over in the bucket for the other beneficiaries if there are any. And there's a host of other complications, such as if the parent dies but they had a spouse at the time of death. A lot of other things that can come up that I can only ascertain by asking a lot of questions.
For sure. And similar to that, like I get clients that ask me about joint ownership with their kids on their bank accounts or their investment accounts. And like you said, every situation is different, but like, what are your thoughts on the bank side?
So with speaking, for example, joint ownership in a bank account with a child, there's some controversy on this topic in the courts. So the courts look at what was the intention of the parent when they added the child to that bank account. For example, the situation with a parent that has 3 children, let's say, and adds 1 child as in joint ownership on the account, then it's an element of the parent not being fair to the other children that are not added on the account. And so the court starts asking questions like, well, why is this child added to the account? Was it the intention of the parent to actually gift the money in this account to the child? Or was it just for ease of administration prior to their death? Why was that? So, and usually the other children perceive it as unfair as well, unless it was dealt with separately in an estate plan. So it's a big topic, and it can be with RSPs and TFSAs. You can, it's not so much joint ownership, but it's more like insurance designations that comes up a lot too, speaking of bank accounts. And it can, if you don't have an estate plan, it can really bother a beneficiary's taxes. Again, I return to the situation where they're beneficiaries in the States or dependent and on ODSP. So I would definitely say that it's good to discuss all of these complications that can arise as part of a normal life with the professional.
For sure. That's great information. We could sit here all day and talk.
Absolutely.
It's not going to be the first time we do this, for sure. And there's a ton of educational bits that we're going to do on estate planning. I've dealt with clients that have passed away, and you have to deal with the executors. And I've never heard once out of family, friends, clients, basically anybody that I know that has dealt with a death in a family. It hasn't been easy, obviously, from an emotional side, but
Absolutely.
from, you know, the paperwork, the just what's involved in that. And we could do a whole other segment on being an executor and things like that. But you know, I do really appreciate this information. This is great. And I want to thank you again for joining us. But I also want to remind everyone
Thanks
that,
so much for having me.
yeah, no problem. No problem. Anytime. But like wealth planning, like I said earlier, it doesn't just involve investing. It involves protecting your assets and your family when the inevitable happens. So if there's anything that piques your interest, you would like to learn more, like I said, please reach out, and we'll take it from there. We can set up a call, set up a Zoom. We're all tech savvy these days, so we can do that. And I also like to mention, I sometimes forget, and I'm reminded by some audience members that if you haven't subscribed to my channel, please do so you can be updated with new content. You know, and this will, no pun intended, thank you, will not be the only video I do on estate planning. So I'm looking forward to providing you with more education and more topics down the road. So as always, thank you very much for watching my video today. And until next time, stay safe, stay healthy, and stay invested. Have a great day.
Bye, everybody.